Good afternoon. I'm John Fortier. I'm the Director of Governmental Studies at the Bipartisan Policy Center. I'm here today with my friend Ned Foley, Professor of Law at Ohio State Moritz College of Law. Both of us have an interest in some books on the Electoral College, and we're here on a beautiful fall afternoon, about a month and a little bit before the election, to talk about the worst case scenarios, meaning some of the things that might happen after the election, not just the counting of the vote, the ballots, but really after the election in terms of the Electoral College, in terms of the Congress counting votes, and the types of controversies that we've seen over the years. We're here not because we think this is going to happen, but because we think clarity about these issues is important. And I think both of us will have some things to say. We may disagree a bit on some of the scenarios, and we'll also want to hear from you and your questions. So before I start, let me mention that if you are in the audience and you'd like to submit a question, you can do so in three ways. You can do so through the YouTube channel if you're viewing that way, on the chat function, on the Facebook comment section, or on Twitter with the hashtag BPCLive. I'll remind you again, but please think about some questions. And now we'll begin. Ned Foley, welcome. Happy to talk to you about this not very happy subject, but let's begin with thinking about some of the scenarios. And I think we're going to focus on one in particular, and that is that there's a real dispute that goes down to the Electoral College maybe having a couple of slates of electors, and then ultimately leading to Congress having some difficulty in counting the votes. Why don't you say a little bit about that scenario? And then I think we're both going to have to find a way to distinguish it from some other scenarios, because there's a lot of, I think, mixing and matching of what's going to happen out there in the press, and some misinformation that we'd like to correct. So Ned, why don't you start and tell us a little bit about this particular scenario that is really vexing for our electoral system.
Great. Well, first of all, it's great to be with you, John. And you and I have had the opportunity to talk about these issues over the years, and I'm glad to be doing it with you in this particular forum. To pick up on your question and point, I'd like to start by referencing the Hayes-Tilden election of 1876. In fact, the cartoon on the cover of the book is one of the cartoons from that period. And that is the reason why I do that is that was a situation in American history where there were disputes over specific states, and it went to Congress. And it went to Congress in the form that you're talking about. There were 4 states that submitted multiple sets of electoral votes to Congress. So Florida was actually one of the states, and it was the first that Congress took up because it took the states up in alphabetical order in the joint session that the Constitution calls for under the 12th Amendment. And so just to focus the discussion, there was, on the date that the electors were supposed to meet under the Constitution all around the country, in Florida, the electors who were pledged to Hayes met and voted for Hayes, and the electors that were pledged to Tilden met and voted for Tilden, each set thinking that they were the valid, correct set of electors from Florida. They submitted their electoral votes to Congress, and that's what set up the kind of dispute that I think that you're talking about, and that has been under some discussion in the media and whatnot over the last couple of weeks. And I think we should talk about how the procedures work for that kind of dispute, what happened back in 1876 for the Hayes-Tilden version of this, and what might happen if that kind of dispute was replicated for this election. But as you said, I think it's important to distinguish that from another scenario. And the historical reference point for the other one is 1824. This was when John Quincy Adams prevailed in a fractured electoral college vote that led to invocation of sometimes what's called the contingent election procedure. It's a backup procedure, a fallback in the 12th Amendment in the Constitution for when no candidate has a majority of votes in the Electoral College. And John Quincy Adams prevailed. Andrew Jackson thought he should have won and called it a corrupt bargain. We could talk about the details. One aspect of that procedure, which is kind of unique and has had some public discussion recently, is that in that contingent election procedure, the House of Representatives votes on a one vote for each state basis. So each congressional delegation in Congress, in the House of Representatives, regardless of the number of members it has, whether it's California or Wyoming or what have you, they each have one vote. And there's been discussion over the last week or so by significant figures, at least as according to press reports, thinking that if there is the first kind of scenario that we were talking about, the competing submissions of electoral votes from the same state, that somehow that would end up in the contingent election procedure like in 1824. And my analysis, based on those historical circumstances and the relevant law, is that's mixing apples and oranges. There are two different procedures for two different circumstances. And I think the easiest way to understand that, at least at first cut, and then I want to hear your views on this as well, thinking about this year, the scenario in which we could get that contingent election backup procedure like the 1824 circumstance would be as if there was clarity in January that each candidate had 269 electoral votes. That would be a 269-269 tie. So obviously neither candidate would have a majority. And let's just stipulate for purposes of discussion that there's no dispute about that between the meeting of the electors in December, on December 14th, heading into the joint session in Congress on January 6th. So everybody knows it's 269-269. Then everybody knows it's going to that backup procedure. That's the Constitution. There's no doubt about that. And then every state would have one vote. And that would be a replica of the 1824 situation. But put that aside for a moment, and just to finish up this thought, if it's the other version, if it's the replica of Hayes-Tilden, where multiple submissions arrive in Congress on January 6th, you don't get to that contingent election procedure until you run through all of the methodology of the Electoral Count Act, which we'll discuss. And the key point here, I think this is the most important point to take away, is that 1876 was not a contingent election scenario. It never went to the House. Hayes prevailed with a bare majority of the Electoral College, and he did that because every disputed state ended up in his column, not in Tilden's column. The Tilden team desperately wanted to get it to that backup contingent procedure. They were fighting for that all the way. It never happened. And understanding that history is essential for understanding what might happen this year and why some of the public discourse of the last week or so, I think, is mistaken.
Thanks, Ned. And I'm going to add and piggyback on what you've said and think a little bit about how we get to this particular scenario, the two slates of electors scenario. I won't go through all of the details because there were many ways we could get there, but Ned mentioned correctly that there's a date, a very important date in December. This year it's December 14th, where the electors will meet. They don't all meet in one place. They meet in their state capitals and they cast those votes. The reason those electors get there is because we have this election in the fall, in November, where people cast their ballots, and through a variety of different procedures in states, we get to a result, and official electors are appointed. They're the ones who are supposed to show up in the state capitals and then cast votes for president and vice president. 1876 is the gold standard for people who want to think about a terrible election scenario. But many of you remember Florida in 2000, which did not get as far as 1876. But I think it's helpful to think about what happened in Florida and what might have happened if it had been pushed a little further, to think about these scenarios where maybe two slates of electors could be appointed that maybe both sides of the aisle would think are legitimate, and then would lead to some real problems in the counting of those ballots in January. So if you remember, in Florida, we had a series of actions by the Secretary of State, by courts, by a number of actors in the recount procedure. uh, the initial count was for George W. Bush. There were lots of decisions that made us recount and rethink what that lead was. But at some point, we had a certification of the election and a slate of electors sent into Washington, and that those group of people were going to be the Bush people, the people who were going to cast votes for George W. Bush in the Electoral College. Now, at the same time, we had a lot of recounts going on, and we might have had one going on further, but the Supreme Court stopped it. Imagine, say that recount had continued, and a different result had come out, that Al Gore had been ahead in the popular vote, and that maybe a court or some other actor had said, well, now there's a different result. You should send in another set of electors. And then another group of names is sent to Washington, and another group of people now representing Al Gore are ready to on December 14th, that's what it'd be this year, cast their ballot for Al Gore. So when we come to January, and January 6th is the key date where the Congress counts the votes, so we can get into how they do that. It's complicated, but those members are going to see two different groups of people. One group voting for Al Gore, and one group voting for George Bush. And what did they do with them? And that's what led, ultimately in 1876, and there were actually multiple states in this state of conflict. How do we resolve those differences? And it's especially acute when we get into the way we do it, when the House of Representatives is in one party's hands and the Senate is in the other. Because again, there could be some disagreement as to really who are the legitimate people who are voting for president as presidential electors. So we can imagine, all sorts of other ways. There's certainly been a lot of talk in the press about perhaps the state legislature could step in and appoint a slate of electors if it felt that somehow the electoral process had gone against its plan for running an election. We could have different two slates with governor's signatures on it, one early, one late, perhaps one sent in a different way. So we do have a number of ways in which somehow two different groups of people could be sent to the counting process. And that, I think, is the key for what we're looking at today. Ned is right. Again, I'm just going to reiterate this other scenario that people like to talk about, the House of Representatives electing the president by this different method of voting by states. That is only going to come about if somehow someone does not have a majority. The easiest way to think about that is, as Ned put it, a 269 to 269 tie. In other years, we might have thought of three candidates splitting the vote, and there are even some more complicated scenarios. None of them very likely, and we hope none of this happens. But again, that's a very different path to getting to an election of a president by the House, whereas this first one is really what might have happened in Florida if things had been pushed further, and what did happen in 1876, where we went up to 2 days before the inauguration, and that inauguration was then in March, where we did not know the identity of the president, and there really was very significant conflict all the way up to near the end, and some question of whether we would really even have an answer as to who the president was come inauguration day. So, Ned, do you want to talk a little bit about what happens next? There's two slates of electors, we're assuming, against somehow a state that matters in this election has come up with two different results, either two different institutions or two different times. And therefore, there are some Trump electors and there's some Biden electors, and they're really decisive in a state. And we come to January, and it is Congress's duty to count those votes. Tell us what happens when they count those votes and the types of issues that we might face, because I think there we have some ambiguity and places that we're not absolutely certain what would happen, but we have some guides as well.
Sure. Thanks, John. I'm happy to do that. And as a preface to doing that, I want to underscore your point about referring back to Florida of 2000 and how that it didn't end up this way, but it might have. I think that's a key point for several reasons. I think since many of us have living vivid memories still 20 years later of what happened in Florida in 2000. We sort of think that any disputed presidential election might look like that. None of us were around for 1876, so we don't have any, personal memory of that, only by looking at the history books. And I think one value of a conversation like this is that all of these historical precedents may be relevant in different ways, and it might be 1876 is more relevant than 2000, depending on how things unfold. The other point that you made, which I think is key, is the Florida legislature was thinking about sending or preparing to send its own submission of electoral votes in 2000 based on direct appointment of electors if it thought that the counting of the popular vote took a wrong turn in the judicial process. They decided they didn't need to do that after Vice President Gore accepted defeat from the Supreme Court decision. But the consequential decisiveness that year was Vice President Gore's decision not to try another move that he might have made. And had he tried to make a move, then 2000 might have had a dual submission scenario like we're about to talk about now. So, law professors like to make hypotheticals for exams for students. And by referencing 2000 in this way and 1876, they're historical precedents. We hope they're still hypothetical and theoretical for this year, but they're not made up out of thin air. There is this history that's relevant. So what happens on January 6th with this complicated statute that we do need to address? But we have to acknowledge that it is complex and convoluted. And it's also important to understand that both the 12th Amendment of the Constitution is relevant, as well as the statute called the Electoral Count Act. The Constitution is the supreme law of the land, and if the Constitution was clear, we would have less of a problem here. But the Constitution says some things that we understand. If it calls for this special joint session in which the president of the Senate presides, and that's the vice president of the United States. Under the Constitution, there's also the Senate president, as people I think know. So that's spelled out in the Constitution. But then the Constitution is very vague in talking about the votes being counted in the passive voice. My English teacher in sixth grade said, never use the passive voice when you want clarity. And yet here we are with the Constitution using it. So Congress, after the Hayes-Tilden dispute, a decade later, tried to write a statute that would help. And it's complicated. It took them a decade to produce because they were trying. It wasn't like they set the problem aside and only came back to it 10 years later. It was difficult to negotiate. They finally negotiated it, hoped it was provisional and would be improved, and it's still what we have. What we do know is that the meeting on January 6th starts at 1 p.m., that's specified, and they take the states in alphabetical order. Starting with Alabama, going all the way to Wyoming. And there's some elaborate provisions we could get into. Each house designates tellers to help the process of opening the certificates. I think from a legal perspective, what's crucial to understand is the statute says that the vice president, as presiding officer, has the obligation to present into this process any piece of paper that essentially arrives on his desk that either is electoral votes from a state or purports to be electoral votes from a state. So the statute by design, and the legislative history shows this, and we can talk in more detail about it as necessary, wanted to minimize the role of the vice president as making decisive decisions in the counting process, I think is fair to say. Definitely the presiding officer, definitely, it runs the meeting, and there is some discussion in the scholarly literature about to what degree in that role there's some decision-making capacity that's of inevitable existence whenever you have a presiding officer. But nonetheless, I think, and there is a question about the relationship of the Constitution, the 12th Amendment, to the statute itself, given that the Constitution does designate the vice president as the presiding officer. But if the statute is going to govern the process, it basically says the vice president should put before this procedure anything that is plausible, that has the claim of being an electoral vote. So in the scenario that you're
quickly interrupt or just let you continue afterwards on this question of the vice president and the role. So if we had a dispute, of course, the vice president today is Mike Pence and would be one of the people on the ballot and one of the people being considered in this controversy that we're talking about. Some slates would be for him, and the other slate might be for Biden Harris. He presides. Now, you and I think, have the same view on this. Both in the Constitution and the law seem to indicate that his role is primarily functionary, that it is to take and open the envelopes. He has to open all of them. Some of them may seem a little more shady than others, but he's opening these envelopes. And who are the votes for? Who are the votes of these electors or purported electors? And that's pretty much it. But you hinted at, and we do recognize that there have been some people who have given the interpretation that it is something more decisive, that the vice president might make some decisions here. Again, we don't agree with that, but that argument could be brought up. So I wanted to just put that on the table. And I know there's more for you to say, but if you want to say more about the vice president's role, or to just continue as to what happens once the vice president starts opening these envelopes.
Right. And yes, I think just a little footnote to that. I think the least well understood episode of the 1876 Hayes-Tilden story is the endgame part, which happened sort of at the last minute with a dispute over Vermont. And we don't have to get into the details here, but it's that part of that dispute that's most relevant to trying to understand, what is the vice president's role, or technically the president of the Senate's role as the presiding officer. Because there was a debate over Vermont about whether there was one submission of electoral votes or multiple submissions. And again, without going into all the details, that became sort of consequential at the end of the process. I think the way the statute tries to deal with that, is you were suggesting, is to say, anything that claims to be a set of electoral votes has to be run through the process. So it would be a very different discussion, and we could have it probably for another day, is if there's only one submission from a state, what happens? That's less consequential, less likely to be problematic. A version of that dispute, frankly, happened in 2004, because Ohio's electoral votes were subjected to a challenge, but that was very quickly dispensed with. And the real issue is, as you said, is if there's competing submissions from a battleground state that could be outcome determinative. And again, I'm going to say what I think is the prevailing scholarly view on this point. But it's not the only view. The problem with the statute is the literature on it has multiple interpretations of the process I'm about to describe. So I could tell you what I think is the better interpretation, but I have to be honest and say it's not the only one out there. But that said, I think, having spent time with this statute, I think the concept is, let's just pick the state. Let's pick Arizona as the first state in the alphabet that might be disputed this year. If there are two submissions of electoral votes from Arizona, that necessarily triggers the obligation of the two chambers to deliberate, because by definition, you already have a dispute. Now, formally under the statute, I think one senator and one representative has to submit their objections to these submissions. This is what happened in 1876. So each submission of the disputed states got formal objections placed to them. And then the statute calls for the two chambers to separate to deliberate. The prevailing concept of the statute is, again, no decisions are supposed to be made in the joint session. It's really just the roadmap of the procedure. But if something substantive has to be decided, the Senate acts separately from the House. So they meet in joint session, they find out that they've got two conflicting submissions, and then the Senate recedes to its own chamber and deliberate. And so what you have then is debate, and the statute talks about limiting the debate so it doesn't take too long. If the two chambers agree on what to do about a disputed state, that agreement should control. Right? The philosophy behind the statute is this should be Congress's decision. So if the House and the Senate agree which of these two submissions is the right one, John, I can't hear you anymore. I'm sorry. I've lost audio on John.
Where there are, again, two different slates of electors. And let's say, as we have today, the House of Representatives in one hand, one party's hand, and the Senate is in the Republican hands. Again, this is the new Senate, so that would mean the election that we have in November is going to keep the status quo. A change would make it simpler in a way if it were in one party's hands or the other. But the dispute, again, as the chambers separate, they might come to some different conclusions about this objection. And again, unless they both came to the same conclusion that yes, we object to this slate is going to be thrown out, then we don't have an answer from the two chambers. But I think, Ned, you may be back, and I don't know if I was filling in where you were, but if we can hear you, if you want to continue, I'm happy to let you go, and then I'll jump in a bit.
Sure. Can you hear me now? Am I? So, so when the two chambers separate, they act by their normal majority rule procedures. So when the House is deliberating in that posture, it's not the 1824 situation.
Yes.
Shall I continue?
Okay. So, Ned, I don't know if you're still with us here. I think we're going to move to questions in the relatively near future. So maybe we should get to the end of this year. I'm going to put a couple things on the table. I do think that this law that governs how Congress is supposed to decide on these disputes, it is complicated, as you said. It tries to favor things like submissions that came in by the right date early enough. It tries to favor more official submissions over less official submissions. And then there's a key point, which many people agree is in the statute, but I think there's a little disagreement. I'm probably on the side of a little disagreement about whether the ultimate decision might be made with a statute, with a slate of electors that has a governor's signature on. It seems to favor that. Doesn't get to the question of could there be two slates of electors with governor's signatures, and how you would resolve that as well. So there's a lot of meat to how to resolve these disputes. But I do think there's a little bit of just the question of who would step in and enforce this against Congress if they weren't able to agree, and whether Congress thinks ultimately that it has to follow the details of this law. It has adopted the procedures in all of its deliberations since 1876 or 1887 when it was adopted, but it hasn't been in the kind of controversial way that was in 1876. So I think the core is that we may reach this loggerheads where Republicans and Democrats disagree, and we're trying to see if this statute or something else can help us get to some agreement as to what are the real votes, who's the winner. If we don't get to that agreement, I think that's really why we're talking about the worst case scenario, because something like that happened in 1876 where they didn't agree, and there were all sorts of machinations that they got to, and almost went up to Inauguration Day. We have this law now; it's helpful, but it might not solve the problem, and that's why we think perhaps this is the worst case scenario. Now, do you want to say a couple more things? Because again, I think we've got enough questions that we may want to go to some of those questions soon, but why don't you go ahead and say a few more things?
Sure. And just quickly, I was making the point that that when the House and Senate separate, the House votes in its ordinary capacity. It's not the 1824 contingent election procedure. Important to understand that. I am of the view, as you suggested, John, that if the House wants to resolve a disputed state one way, and the Senate wants to resolve it the opposite way, when that comes back to when that gets reported back to the joint session, my interpretation of the statute is that if one of the two submissions bears the signature of the governor, the statute demands that that be the submission that be counted, that the governor's signature in that context functions as a tiebreaker in that divided situation. You're absolutely correct. The statute is silent as to what do you do if both submissions have gubernatorial signatures on them. It's just, and that would be even more chaotic. And you are also correct that historically there are contrary interpretations that in some situations you would invalidate both submissions as opposed to simply counting the one that bears the governor's signature. The problem with invalidating both submissions just procedurally is that then opens up another line of potential chaos, because if you get to, another key point here is Congress is required to resolve a dispute on each state before you go on to another state. So if the dispute is over Pennsylvania, let's say, you can't get to the next state alphabetically, I think it's Rhode Island, until you figure out what to do with Pennsylvania. So that's why some of my writing has been concerned that Congress could kind of derail in the middle of the process if there's serious disagreement about whether the governor's tiebreaker position is correct, or whether you're supposed to invalidate both submissions, say from Pennsylvania. And if there's partisan and disagreement about that, and the two chambers are in disagreement, it could get very chaotic. And then just last point before finishing up, if you get to the end of the alphabet, Wyoming, and you've invalidated, let's say they have invalidated Pennsylvania's 20 electoral votes, there's a serious question on the Constitution how you calculate whether or not any candidate has an electoral college majority. These two theories have been around since the 19th century. They were debated at the time Congress adopted the statute, but they couldn't agree, so they just left it ambiguous and unaddressed. So quickly, on one theory, you reduce the denominator because you've thrown the state out completely. It's as if the electors weren't appointed at all. So instead of it being 538 electoral votes, it's now 518. And if one of your two candidates has a majority of 518, they're president-elect without going to that contingent 1824 procedure. On the other hand, if you accept the proposition that you keep the denominator at 538 because Pennsylvania tried to appoint electors, we just don't know who they really were, then that would cause no candidate to have 270 votes, and then you would go to the House contingent election procedure. But there could be serious debate and contestation in Congress about where you are in the process and which fork of the road you take.
Great. And I'm going to just throw one last thing out before I have questions, of which there are many. And again, if you do want to ask an additional question through the YouTube chat function, on the Facebook comment section, and then in Twitter using hashtag BPC Live. The last question, and I'll give my own answer, and maybe you'll chime in as well, is if we ended up not being able to get to any answer by Inauguration Day, what would happen? Inauguration Day is January 20th. There's a noon date, and there's some question of this Congress counting has some limits on time and how you dispute things. So maybe some people think you can't get there, but if we really were stuck and got to that date, I think the answer is that we would end up going to the Presidential Succession Act. And in this case, the Speaker of the House would take over if we had not been able to select both a president and a vice president. And if that's who it is today, it would be Nancy Pelosi, the leader of the House. although technically she would be there temporarily unless if the election were resolved sometime later, someone could get resolved and then become president at a later time. I'm not saying that there aren't some scenarios that some people might think there was a dispute that went in a different direction, that had a different answer. But if we literally do get to noon on January 20th, I think a vacancy in the presidency calls for the line of succession to kick in, and there is a line of succession at that point, beginning with the speaker.
Yes, I agree with that. I think the 20th Amendment to the Constitution is unambiguous in this respect. So one point of clarity is that if you accept the predicate, as you just said, that there is no president-elect and no vice president-elect because the counting process remains incomplete, and that's the premise, then I think constitutionally it's absolutely correct that this line of succession statute is invoked pursuant to the 20th Amendment, and then it would go to the Speaker of the House to step in, as you say. The thing that concerns me is if there's debate and contestation over that predicate point. It's at least possible for me I can imagine a situation where one party to the dispute believes that this is the case, what we've just been describing, whereas the other side of the dispute doesn't believe that and claims instead that they've exercised power to complete the counting process and produce a president-elect. And that would lead, to me, the ultimate worst-case scenario, because then you would have two different people at noon on January 20th claiming at that moment all of the powers of commander-in-chief, including the nuclear codes and everything that follows. And the country can't tolerate two commanders-in-chief at the same time. And so to me, that would be the most dangerous situation.
Great. Okay, so we're going to go to some questions. I'm going to begin with a question. Are votes still counted after the safe harbor date? We'll have to explain what that is a bit. And then there's a second part of the question, or second question. Does Senate have any role in case the House would not be able to find a result in voting in case of a tie? And I'm going to say something about that. I guess the two questions point in different directions. They're pointing at different processes. The safe harbor date, we hinted at it. It's a date that's 6 days before those electors meet in December. This year, it's December 8th. And it was very important in Bush v. Gore. If you remember, the court was deciding that case on the eve of that safe harbor deadline. And without getting into all the details, they didn't believe that you could fashion a new type of appropriate recount in time to meet that deadline, and that the state legislature had intended the election to be done by that time. The reason that date is important in the law is that there are some greater protections in the counting of the vote if you get those ballots in, those slates of electors in by December 8th this year. And again, the court would say that the state laws would intend to have it done by then, and might give some preference to ending the count then as it did in 2000. So, I think it's a significant date. Could electors be selected after that date? Yes. Maybe even they could be selected after the date they're supposed to vote. That's a little more controversial. But as Ned said, when Congress starts to see these slates of electors, they might see some slates that seem very legitimate. They went through the regular process, and there might be some that seem a little less legitimate. Seem that they were purported to be electors. They were sent maybe through a slightly different process. And so it's a good thing to meet that deadline. The court may want you to, but it doesn't absolutely keep a slate of electors from getting into Congress's hands, which could happen in another way. The second question, I think, is more about the contingent election. The House would elect the president. I think the question is really about if that does not get a result, which it could end up not having a result, because you need an absolute majority. You need 26 states of House delegations to have a majority. If you don't have that 26, you have 25 and 25, or 25 with some split delegations and less. Then you would go to the Senate to pick the vice president. And the Senate acts in a different way, but basically like it does in normal times with one senator having one vote. And perhaps that Senate could elect a vice president, and the vice president could go on to be president. But again, these are the two different paths that we're talking about. One is the path of, are we talking about a state, we just can't figure it out, there are several electors and Congress has to sort that out and it's really disputed? Or are we talking about a tie or some sort of lack of a majority where there's a different procedure, the House and then the Senate for the vice president?
John, can I just jump in quick on a couple of points on that? On the first point, I agree completely that a state, if it misses the so-called safe harbor deadline, is not in complete jeopardy yet. It loses the benefit of the congressional promise associated with the safe harbor, but there's 6 more days until the meeting of the electors all around the country, at which time it could finish up the counting of the popular vote in time for the Electoral College meeting on December 14. My own view is that December 14 is a hard stop in terms of what happens in the states because of how that issue was resolved in 1876. Florida, again, attempted to revise and do a recount after that date that showed Tilden to have won. And the process used in Congress invalidated that on the premise that nothing that happens in a state after that date can be valid because every state must have its electors meet on the same day. So it's whatever state law is on December 14th that determines the state's electors. So if they fail to complete the counting of the popular vote, then they don't have electors to meet that day, and they can't. And if they try to revise it, they can't do it. Now, they could try to review that and repudiate that precedent, and then it really would be up to Congress on January 6th. But I do think that's a relevant historical precedent to be aware of. And just one teeny point on the other question about the Senate's role in a 269-269 tie. If the Senate elects a vice president, but the House fails to elect a president by January 20th, then under the Constitution, the vice president-elect becomes acting president with all the powers of the acting president, including being commander-in-chief, but it is temporary. If the House continues to deliberate and resolve its deadlock, then whoever the House would choose as president would immediately become the president, and the vice president would revert to that vice president role.
Yeah, I agree with that. So here's another question. Is it possible for state legislatures to approve a slate of electors different from those selected by voters? Do you want to take that, Ned? I have some thoughts, but take that.
It would definitely be contested. And Congress would probably have to, because that would be our 2 slates scenario, right? You'd have the 2 submissions and it would go to Congress. So it would be precisely the kind of dispute that we're talking about. And I do think the key insight from both 1876 and the question is what ultimately is most important is what arrives in Congress on the vice president's desk that has to get put to through the process, because any piece of paper that purports to be electoral votes has to be put through the process. So even if it's not a correct legal claim, if it gets there, it's in play. So then if we could, as John said, the public discourse and the congressional debate, it may make a difference about how serious a claim it is. And frivolous claims to electoral votes may be disposed of very quickly. If a state legislature really tried to repudiate the popular vote, and that's what the Florida legislature was thinking about doing in 2000, if that story had taken a different turn, that would bring into questions under the federal law. There's something, it's Section 2 of Title III, and it says that if a state fails to conduct the November 3rd election, and most people have in mind things like hurricanes or other circumstances that would mean it impossible to actually hold an election, then the state legislatures can come in and figure out a different manner of appointing electors. But a legislature might try to make the claim that if it can't count the popular vote at all, because it's mired in controversy or what have you, then it would be able to step in and claim a failed election scenario. Now, I think that would be very dangerous, and it would be declaring failure. It would say the state had failed the exercise of democracy. It meant that we had an election, we tried to have voters vote, but we can't do it. I mean, it would be a terrible circumstance, I think, for the people of that state and the country. But as a matter of law, there is this statute that would be relevant to that question.
And I might add to that there are ways in which the role of the state legislature is paramount. The Constitution talks about them, and I think just if we remember from our earlier history, and certainly sanctioned by the Constitution, there were states early on where there was no popular election. That the selection of the electors for president and vice president were made directly by the state legislature. Now, since we all have popular elections, that laws have been passed, and there's a due process where we expect us to follow through that election to its conclusion. The idea of a state legislature stepping in against that process makes it seem not as legitimate, right? The state legislature was spoken by passing a law that says, here's the election code, the people will speak. I will note, though, however, in Bush v. Gore, not the court's decision, but the three judges in concurrence, the three more conservative justices, are took up seriously the argument that all of the things that had happened after the November election, the court decisions, the decisions administratively, local board decisions, had really distorted the election scenario, the election scheme that the legislature had put in place. And the legislature would have felt it was justified if it had gone forward and appointed electors. Now, that argument wasn't absolutely adopted by the court, and they didn't actually appoint the electors. But the idea of somehow we've gotten away from what the real election law is, so the state legislature has to step in to save that is an argument that is out there and that has some power to it, and would have some issues once we get to Congress again, because Congress might think that's a good thing, or might look and say, well, it doesn't have a governor's signature, perhaps. But it is something that I think there's an argument in the more extreme cases of something going wrong with the election or something being really radically changed, that might cause the state legislature to think that stepping in was actually saving the election rather than distorting it.
Yeah, no, I think that's right. Can I just say one more thing about that? Because I think that's a very important point. And I do think it is a point of some uncertainty among the scholarship on this question, because, as you say, there is the concurrence that's there, no question about that. But the safe harbor provision that you referred has a complicated interplay with that. If a state legislature attempted to repudiate the procedures that the legislature has already put in place in advance of the election for figuring out the vote count, and those procedures are working towards and are capable of achieving final determination, that's a statutory language, by the relevant date, December 8th, in order to get safe harbor compliance, I think there's also an argument, debatable, but an argument that the state legislature can't repudiate its own procedures that it's put in place to try to get to that safe harbor deadline, and that if it did repudiate it, it could only do so when the whole system had failed. Again, very complicated, and so let's just leave it there and bracket it as a point of controversy.
Great. So let's turn to another question here. I think we may have answered this more or less. This is a short one, but if the speaker would have to take over for the presidency on January 20th temporarily, would she have to resign permanently from her speakership? And I think the answer there is yes. The answer is that both, I think constitutionally, there's a sense that you cannot serve in the legislative branch and also hold office in another branch, in the executive branch. And the law itself is clear about this, that if the speaker were to take over for the president in any circumstance, in the case of the death of a president, or in this case where there's a vacancy on January 20th, that means leaving Congress. Now, maybe they could go back afterwards. There might be some ways, but it is a permanent departure from that job in order to take over the presidency, even if it is for 10 minutes or a week. The speaker would be out of the job if he or she did that. Is that
Yes,
agree,
no, that's
agree, Ned?
yes. In order to become acting president, the speaker must resign both the speakership and the seat in Congress. I think after that individual was no longer acting president, then there could be a subsequent question about becoming a member of Congress again in a new election. And you're more of a congressional expert than I am, John, but my understanding is technically there could be a Speaker of the House who's not a member of Congress. So Congress could choose to bring an individual back as Speaker who didn't have a seat for a period of time. But that's quite speculative, I think.
I think you're right. Yes, I agree with that. So there's a question here, and I think we've touched on it a bit, and that is, and maybe you know this argument more directly, but can you address the article by Lawrence Tribe and others where they indicate there is no way the legislature could send a competing slate without changing state law?
Yes, I'm aware of that article, and with respect to the authors of that piece, that's not my understanding of the situation. My analysis is different. Again, a lot of this is very complicated. The one part of that article that I'm most in disagreement with is the idea there that a state could ignore the December 14 deadline, and that as long as the state finishes counting the popular vote by January 5th or 6th and gets its paperwork in by that deadline, that's functionally okay. I think that's a mistake and would be very dangerous for a state to take. Again, Congress may have the power to kind of ignore constitutional requirements or to interpret the Constitution differently than it has in the past. But again, Justice Joseph Bradley, who cast the deciding vote in the Hayes-Tilden dispute as a member of the Electoral Commission for that purposes, made his decisive ruling on the premise that a state was not entitled to do anything new subsequent to the meeting of the electors. And I didn't see anything in that paper that was a reason to contradict the analysis of Justice Bradley or its status in American law.
Okay, I have another question. This one's from Corrine King, and the question is this. Given that there may be a number of issues in this election that the court may have to litigate, are there concerns that a conservative majority on the Supreme Court could impact the neutrality of their decision-making? And what can the 2000 election teach us about the 2020s? And maybe, you can answer that question, but I mean, another maybe big one related that she's getting at as well is, are we going to see the court step in at a later time? We obviously have seen recently in 2000 the court stepping in before the electors meet and resolving matters relating to the ballot counting, the state's counts and what they come up with. But are we likely to see a court step in later when Congress is counting the ballots, counting the electoral slates, or we have some dispute? What role might the federal courts, the Supreme Court, play after the electors have already cast their ballots, or do you see not a strong one?
John, I think that is a really important point. Bush versus Gore was decided while the issue was still in the state of Florida, so to speak, before the electors met. It did not involve the subsequent phase of the process moving to Congress. Once a election is essentially out of a state and in the hands of Congress, so after December 14, on its way to January 6th, I think a serious question arises under the so-called political question doctrine, which is a technical term that the court uses to keep out of certain issues that it believes belong to another department or branch of government. And the Supreme Court has invoked that doctrine for impeachment, for example. Impeachment can raise constitutional questions, but those constitutional questions are not answered by the U.S. Supreme Court as constitutional questions normally are, because the Constitution itself assigns the impeachment procedures to Congress exclusively, and the Supreme Court's acknowledged that. And there is a lot of discussion, both in the literature, academic literature, but then this was actually touched on in some of the Bush versus Gore opinions, even though it wasn't absolutely necessary at that time, that the 12th Amendment does designate Congress, the joint session of Congress, as the constitutional body to receive the electoral votes from the states and to go through this special process. And so it's quite possible that the Supreme Court could say that once the election is in Congress's hands in that way, it's off limits to the court. I've seen a lot of scholarship evaluate it that way. Now, the Supreme Court has never definitively ruled on that question, so we can't say for sure, but that's a reason to think that this year might not be like 2000. And again, that goes back to the point that what was conclusive in 2000 was Al Gore's decision not to take the dispute to Congress. And just last point on this, for the Supreme Court, even at the earlier stage, to be decisive in a way that affected the counting of the popular vote in a state would require a constellation of events that are improbable, right? You have to have a very narrow margin, like Florida, 537 votes. You have to have something to fight over in court about, like hanging chads. You can't just sort of automatically assume that because you want to take a dispute to court, that you're going to get the answer that you want in court. So let me leave it at that.
Great. Well, we're nearing the end of the time here, so I'm going to make one quick last comment, and then I'm going to invite you to also make a final comment before we close. I do think just one thing we've tried to hammer home from today is that there is this very difficult scenario, and it involves a state having essentially two results, and those results having some official sanction. They have electors, and Congress wrestling with those results. Many ways Congress might be able to resolve those easily, but in the worst case scenario, where the bodies are divided, where there is real difference of opinion, it's difficult sometimes to see how we're going to get resolution. And we hope we will find it, but it is something that is one of the key and really worst scenarios. The other thing we mentioned is that is a very different scenario than the House voting or the tie scenario, that no one has a majority in the Electoral College. That's also a very obscure and rarely has happened scenario, but it is very different. It's a different track. And so many people have been mixing those things up or mixing them together in a way that maybe isn't helpful for really thinking about what could happen afterwards. But I'm going to give the last word to you, Ned, if you can, in a minute or so. Your big thoughts. We were here today to talk about the worst case scenario, your big thoughts, and then we'll wrap.
Sure. Well, thank you so much for this opportunity. I guess if these worst case scenarios are anxiety provoking, I think there are some things that could happen to help reduce risk and avoid the problem. The easiest, most straightforward one is a bill that Senator Rubio has in front of Congress that would give states more time to resolve any dispute or issues about counting the popular vote in a state. And the advantage of that is all of this uncertainty and ambiguity about Congress disappears if you get closure in the state, because that's, again, the lesson of 2000. If like Florida in 2000, it ends in Florida, it doesn't go to Congress, the January meeting is essentially ceremonial. So this bill would give states the more time to finish up themselves so as to avoid disputes in Congress. So I think that's the most important thing if you're trying to reduce problems, reduce risk. Beyond that, and this probably is harder, but might as well say it now, because if there's a sense that trying to solve problems are easier now before Election Day than after Election Day, if it was a prevailing view that the governor's tiebreaker interpretation is the correct one, for at least for those situations it applies, it would be helpful for Congress to go on record and just say so in 21st century language, as opposed to the arcane verbiage of the 19th century that gets interpreted to that conclusion. So just a clarification of some form that yes, the governor's tiebreaker is the right one. So, that would be my final thought for today.
Thank you to our audience. Thank you, Ned Foley, Ohio State Law School and author of Ballot Battles. And we are closing now with a hope that we are not to face these scenarios that we talked about today, but with also the hope that education about them will lead us to better resolution and perhaps fixing some of these issues in the future. Thank you.